Well, welcome everybody. Good morning. Thank you so much for joining us today. My name is Adam White. I'm director of the Law School's Center for the Study of the Administrative State. As I often like to joke, I want to make very clear, I run the Center for the Study of the Administrative State, not the study for the administrative state. That's basically every other law school in the country. But I run the Center for the Study of the Administrative State, which I think was a wonderful name my predecessor Naomi Rao chose, because there is so much to study right now in administrative law and in public administration. When Naomi founded our center, one of her goals was to study not just administrative law narrowly defined, but to study the ways in which administrative law and administrative agencies intersect with other parts of American government and American law. And so it's a real honor and pleasure for my center to have the opportunity to co-host this wonderful event that my colleague Adam Mossoff and the Center for the Protection of Intellectual Property have organized. And so thank you so much for joining us today. And Adam, I'll turn it over to you.
Thank you. So from one Adam to the next, thank you. It's a pleasure to be co-hosting this very important conference with our fellow center here at Antonin Scalia Law School, Center for the Study of the Administrative State. I am one of the founders and directors of the Center for the Protection of Intellectual Property, and we actually created the Center for the Protection of Intellectual Property because centers that study the intellectual property at academic law schools around the country, as a general matter, tended to be much more skeptical and critical of intellectual property, and so we created the Center for the Protection of Intellectual Property in order to balance an academic debate and create a more vibrant discussion to and therefore promote data-driven, rigorous scholarship on the role and function of intellectual property in the commercial economy and a flourishing society. And of course, this requires us to study not just how intellectual property rights function in the innovation industries and the creative industries, but also how these rights are defined, secured, and addressed by government agencies and by the various branches of the governments, the courts, the legislatures, and of course today, the administrative state. We were really quite pleased that we actually began this event and began preparing for it even before the Supreme Court granted cert in oil states. For many of you know, this is the case that the Supreme Court will be hearing oral argument on at the very end of this month, November 27th, that addresses the constitutionality of the Patent Trial and Appeal Board, the PTAB. And regardless of how that case comes out, these intersections, a very important intersection of administrative law, patent law, and of course constitutional law raises tremendous questions for the creators of patent innovation, for the users of patented technology, and ultimately for our innovation economy and the growth of our society. So again, thank you to Adam and CSAS for joining with CPIP for this event. And of course, I would be remiss not to thank the people who actually made this possible. Of course, that would be Christina from CPIP and Leah from CSAS, and of course the supporting fellows and staff at CPIP who also lended their assistance, very valuable in making possible events such as this. So thank you for coming, and when we have a great assortment of papers addressing all aspects of the PTAB, and without much further ado, I'd like to call up our first panel for our first presentations of papers and commentators. So thank you.
Hey everybody, Mike's right.
Well, good morning, everybody. My name is Devlin Hartline, and I'm the Assistant Director here at CPIP. And I also teach patent law at Scalia Law. And I thank everybody for coming out today. It's great to see so many people interested in the PTAB. We have an excellent panel for you all this morning. We have Professor Saurabh Vishnubhakat from Texas A&M School of Law, who's going to present his paper. Commenting on that paper is Professor Stuart Graham from Georgia Tech. And we also have a paper from Chris Walker of Ohio State University and Melissa Wasserman of University of Texas School of Law. and that will be commented on by Adam White. So without further ado, I open the floor up to Saurabh.
Thank you, Devlin. Thanks to the Adams and to all of you for coming. It's a real pleasure to present this research. It's the result of an agenda of research that I've undertaken on the administrative process of the patent system. I will say that I began my career as an advisor to, among other people, Dr. Grimm, while at the United States Patent and Trademark Office. I haven't been there for about 2.5 years now, but needless to say, the views represented here are very much my own. And as I express those views, it'll be clear that it probably wouldn't be confused for the agency's position. So, ex post power over patent validity. This is the subject of the paper. I exhort us to rethink patent law's validity power because we are now in the midst of a sort of reaping the results of a very dramatic transformation that's taken place over the last third of a century, a little more so, and it's been the reallocation of power to look at patents that have already been issued, reevaluate their validity, a power which traditionally lay in the courts and has now progressively been moved over to the agency, to the patent office setting. This began in 1981 with the creation of ex parte reexamination. It was bolstered further in 1999 with the creation of inter partes reexamination, and now finally in 2011 with the American Invents Act has been broadened substantially by the introduction of inter partes review, covered business method review, and post-grant review to really take a strong and vigorous second look at the validity of these patents. And the traditional account, the reason given traditionally for why this reallocation was taking place, why we should take power from the courts and give it to the agency, has been expertise, right? Expertise lies at the heart of most of the concerns that are articulated in all three of those administrative reallocations. When we care about cost, it's because it costs a lot of money to teach lay juries and even lay judges how to think about scientific issues underpinning patent validity. There's a lot of delay because inexpert judges and juries don't really know what they're doing in the same way that administrative agencies could. And then finally, aside from cost and delay, there's the question of accuracy. A judge or a jury is simply less likely, goes the theory, to get the answer right than the agency which issued the right in the first place. So for all these reasons, if we could take it to a more expert forum, we would get better results, faster results, cheaper results, and the world would be better. What my paper argues is that this is incomplete. There is a desire for expertise, yes, but expertise is not the whole story. What my paper attempts to argue is that the way in which this reallocation has taken place reveals a preference on the part of Congress, and certainly on the part of the Patent Office, in how it's exercised its power, not only to have expertise be a part of the system, but also political input. Have political input be a part of the way in which we reevaluate patent validity. And so what I'll do is briefly summarize the case for why I think political input is a part of the structure of administrative review and what effects this has had. Okay, so the power over patent validity, as it is delegated to the Patent Office and exercised in the Patent Office, isn't just a wholesale power. It's actually been carved up into two sub-powers. One of them is the power to actually adjudicate the validity. It's usually given to a re-examiner, or in the case of AIA reviews, the Patent Trial and Appeal Board, which consists of administrative patent judges. Okay, those are adjudicators, and their work, like anything else in administrative law, their adjudications would be subject to judicial review. On the other hand, the initial screening and the decision to institute reviews to ensure that this isn't a waste of the agency's time and resources, that is delegated not to the adjudicatory apparatus in the agency, but to the political apparatus of the agency. It was, prior to 2001, delegated to the director, or excuse me, the commissioner for patents. And since 2001, the director. The political head of the agency would have this power. Now, in that time, the commissioner would subdelegate that power to the re-examiner, and the director subdelegates that power to re-examiners and ultimately the PTAB, now in AIA review. But what effect does separating this power have? Well, although adjudication is subject to judicial review, the initial decision to grant reexamination or IPR or CBM is immune from judicial review. The screening, the politically inflected function, is immune from judicial review. The adjudication is subject to judicial review. And this is very, it's quite a bit more salient in PTAB practice, modern PTAB practice, than it ever has been before, because if you can reframe adjudication-related tasks as pertaining to screening, well, then the agency can insulate itself from judicial oversight. Okay? So theoretically, this could happen, and of course, that's not a very sort of convincing argument in and of itself. So here are some examples in which the agency actually has done exactly this. In the America Invents Act, the IPR statute requires that petitions for review be pled with particularity. Okay? If you don't plead with particularity and explain what the quality of evidence is and why review should be granted, review should not be granted. That could be cast as a question about the quality of evidence, or it could be cast as a question about whether it would be a waste of time to even look at this. It could be about adjudication, or it could be about screening. And the agency, unsurprisingly, said it was about screening. I think there's a reasonable argument it is about screening. But the question of whether judicial review should be available could be understood as saying we don't look at whether the pleading with particularity requirement is satisfied at the moment institution is granted or denied. If it is granted and we go all the way through to the end of the administrative adjudication, however, it should be subject to ordinary judicial review along with everything else that came along. Right? So it's a ban on interlocutory review, but not on all review. The more aggressive position, the one staked out by the Patent Office, was to say it bans all review. Even after a final agency order has been entered, that component of what went into the adjudication cannot be reviewed. And that's what the Supreme Court ultimately approved in the Quozo case in 2016. So this distinction between adjudication and screening, Quozo was really the opening salvo in a much larger agenda of the office to try and insulate itself from judicial scrutiny. A second requirement of the agency that could be understood as something that even the Quozo court said had to do with adjudication and in terms of scope and impact extended well beyond just the screening function, just the institution decision, is the border between the court and the agency as substitutes for each other. And that is the one-year time bar in inter partes review. When you file a petition when you file an infringement action in U.S. District Court, the defendant has 1 year to go to the agency and seek a defensive reevaluation of the patent. If you don't do it in that year, you can't do it at all. That's the one-year time bar. Now, the agency has said that pertains to screening. It depends on it pertains to whether you can accept the case or not. But if the agency decides, you know what, we're just not going to care about the one-year time bar. We're just not going to enforce it. Or we're not going to enforce it as robustly as the statute says we should. All of these questions of whether the agency is following its statutory command or doing it the way it's supposed to be doing, all of these would be subject to judicial review eventually. If you take the position that it pertains to adjudication, or you take the position that it has to do, in terms of scope and impact, with something other than purely screening. The agency has said, no, this is just screening, nothing more to see, and we are immune from judicial review. This is the Wi-Fi v. Broadcom case, now pending before the en banc Federal Circuit. And I think it is the first real test in the post-Quozo world of whether screening and adjudication have been conflated in this way, and sort of how far the courts are willing to accept that. The third, and this is the one the third example I'll close with, is the requirement of completeness in agency adjudications, in the decisions, right? This is the SAS Institute case now before the Supreme Court. It's actually being argued the same day as oil states. And the question there is whether the agency, when granting review on some but not all of the grounds of a petition, right, classic screening, then goes on to issue a final decision that doesn't address all the claims that were presented to the agency requesting review. Okay? Some but not all. The statute says any claims that are challenged must be addressed in a final written decision. The agency is not doing that. And the agency says, well, we don't have to do that because subject to the screening power, which remember is unreviewable, we can institute review on some claims and not all of them. So we have the power to constrain the obligation imposed on us by Congress by simply pointing to our politically unreviewable screening power. It's immune from judicial review. So this distinction between screening and adjudication is a really strong and powerful tool that the agency has identified, I think, to insulate itself from judicial review. The more it can make things look like screening, the less judicial the less answering it has to do to the judicial powers that oversee it. And this leads to opaque decision-making, right? I don't think it's necessarily inherently good or bad that the adjudicatory process has been infused with politics in this way. I think there are costs and there are benefits. But if we inject politics into a property rights system in this fashion, then in order to ensure that the agency doesn't go off without any check or any balance on its power by the judiciary, some measure of meaningful judicial review should exist. And the agency itself should engage in adjudication honestly. If it wants to engage in political decision-making and implement its policy priorities in a political fashion, that's its prerogative. But there are more principled, more institutionally honest ways to do that, and I'll point to just one in my final word here. The practice of stacking panels to reach particular outcomes is something about which a lot has been written in the popular press, or the popular patent press anyway. I've identified 3 examples in my paper about how this practice has actually been carried out and the problems with it. When you want the agency, when the agency leadership wants a PTAB panel of 3 judges to come to a certain decision, they will let the decision come forward. If they don't like it, they'll wait for rehearing to be granted and then just stack the panel with additional judges who will vote to make it come out a certain way. If you do that and fail, the agency will do it again and will keep stacking the panel repeatedly until it gets enough votes for the position it wants. That is not adjudication. I think that's incrementalist political fiat. I think the way to do it in a more principled fashion, in a way the agency already has the ability to do, is see a decision that it likes, point to it and say, this is precedential. There is a standard operating procedure in the agency already that's been in place to say these are the opinions that are illustrative of an issue. These are the opinions that are informative on a given issue. We sort of synthesize and curate opinions to provide some guidance. And then if you want to take that normative guidance and make it binding, designate it precedential. When you do that, the way courts do, you're pointing for future decision makers to a single decision that they should use as a benchmark. If you don't do that, if you're stacking panels and sort of forcing outcomes in a case-by-case, untethered analysis without any ex-ante guidance, I think that's much more the political style of decision-making that has no place in adjudication. So there are these principled alternatives. The agency hasn't used them, and that's what I hope to get your feedback on and Stu's as well. Thank you.
Thanks, Sorb. Hello, everybody. It is a great pleasure to be here. Thanks to the organizers and to Georgia Mason for making this possible. I'm going to spend a few minutes discussing Sorb's paper. Before I do that, let me just say a few preliminary things about it. It's a great pleasure to be reviewing a co-author's work. Certainly not a co-author on this paper, but on previous endeavors. We did indeed serve together at the PTO. I think that's I think that recommends this paper to you, which I would recommend. Maybe more powerfully than the works of some others, because the feature that Professor Vishnu Bhagat has is that he has actually spent time inside the USPTO. He has seen this with his own eyes. He understands how the sausage is made, as it were, and so he has a particular and unique perspective on these things that I think is worth paying attention to. I'll also say that this is early stage work, and I'll treat it as early stage work, and take the discussant's privilege of even suggesting maybe some reformulations or some major things that might be done with it. Okay, with all that said, let me jump into my comments. Ordinarily at this stage in a discussion, I would spend some time reviewing what the paper does, but given the limits on the time we have and the really fine job that Saurabh just did in presenting the paper, I'll dispense with that and go right to the commentary and critique. I would say one of the things that, as a reader, was unsatisfying from the get-go was that there appeared to be some rather important unstated premises in the paper that I think you dealing with would improve the paper substantially. And it wasn't clear to me what those premises were, and they have implications for how the rest of the paper develops and the argument develops. So you seem to dance around a couple of issues, and maybe this was purposeful, but I still would like the paper to spend more time on this. And the premises were: are you arguing that essentially we should be viewing the patent right from a property rights framework? Is that the concern about the patent office's potentially arbitrary and capricious decision making, or is the concern that there is inadequate review of what's happening, and because there's inadequate review, that raises a host of, of thorny and, a parade of horribles for us. I'd like to have some sense of that, and as I go forward, you'll see why those, making that clear from the front end, I think would improve things, at least from the reader's perspective and understanding where you're coming from. My sense is that comes clearer in my next critique, which revolves around the issue of the patent office introducing political decision making into the validity process. Right? I think you do a very nice job of separating for the reader the main elements in the patent law and helping the reader understand how questions of validity and the adjudication of questions of validity have developed over the last several decades. That said, it's not clear to me why we should be entirely concerned about the introduction of politics into this process, right? It becomes clearer if your argument is an argument stemming from a property rights standpoint, okay? It becomes less clear if the perceived problem is one of review. And why do I say that? I say that because even if we take for granted that politics is seeping into the process in some way that we might consider to be problematic, it's not clear at all that there aren't other adequate checks on a political process run amok, as it were. So, for instance, we can imagine, and you and I both were inside the patent office, so we can imagine a whole host of things in which the over politicization of this process might be limited, right? First of all, legislatively, right? Hearings, demand for information, or lawmaking statutes themselves. there still is judicial review of many of the things, even the question around which you are concerned about this separation of screening. There is no judicial review of the screening, but there certainly is the opportunity for judicial review of the way in which this is being practiced. And indeed, you point to some of the ways in which the Supreme Court have reviewed and are reviewing some of these questions currently. There's also, obviously, executive review, right? The director can be replaced. The director can be schooled, taken to the woodshed, as it were. There are executive orders. There are a whole host of things that the executive can do, right? And there are also a whole host of things that the stakeholders can do. So they can exert informal pressure. They can exert. They have considerable inputs through their lobbying activity with the other branches. They have the ability to inform the courts, for instance, through amicus briefs. There's also media, right? Media plays an important role. I think we only need look back at the reports of Stanford laser cat toys and peanut butter and jelly sandwiches to understand that there are indeed ways in which politics and the process and all of the players have a substantial opportunity to essentially serve as a check on a political process run amok. Okay, so it's not clear to me also why it would be that the courts would be particularly well positioned to be the bulwark against these kind of abuses. We only need look at a whole range of literature. There's a wonderful Oxford handbook on judicial decision-making, decision behavior that I recommend to you, and I have it in the notes that I'm going to share with you, several of the chapters there. Chapters that point out the way in which the political science literature has studied and researched questions into judicial decision-making as regards election results, as regards interest groups, and even as regards the elite class in which judges are, right, in terms of their social circles, right? All of which may potentially have influences that are actually much more problematical than the kind of political influences that presumably come from a larger polity. Okay. Lastly, let me just say too that, and on the same point, there is a long literature, and I think it's worth taking a look at this, on how the interaction of the agencies with the judiciary, with the executive, with the legislature, commonly known as positive political theory, and the way in which these interacting political forces, right, political bodies, allow for or restrict the ability of governments to offer to economic actors credible commitments. There's a long literature on credible commitments. It comes originally from Oliver Williamson's work. Douglas North, another Nobel Prize winner, has written about this. Famously, Levy and Spiller have written about this, as have many others. And so I do think that in the realm of these sort of checks that I was talking about earlier that come from many places in the polity, it's worth taking a look at and thinking about that literature. Lastly, and I'm sure I'm probably completely out of time, it's also not clear to me from the current paper how and in what ways the PTO's ex ante decision making, or how Congress has approached the problems that Congress may have observed, is actually a problem. And this is where I get to use my sort of cute slides. and involve the audience. Anyone know what this is?
It's a bug or a feature.
It's a feature, not a bug, right? And this is, and I use this slide particularly because, you know, many of the attributes that you were ascribing as bugs to the Patent Office actually are indeed a feature, right? Or at least one can view them in that respect. So what were many of the perceived problems, right? The inability of the system to deal with many controversies, right? The fact that that these controversies were rising, were raising a lot of questions that neither the courts nor the Patent Office were adequately dealing with. There were a whole parade of horribles that led to this legislation. Now, for instance, you point out the covered business method, ex post validity determinations as one egregious example of a bug, right? Well, if indeed covered business methods was a response to sort of rent seeking by a particular interest group, then yes, that is indeed the case. But on the other side, if it is a response of Congress to a problem that the PTO had created and was not currently fixing, that the courts were inadequately dealing with, and all we need to do is look at the 101 jurisprudence to have a good sense that indeed the courts have not adequately dealt with some of the important issues there, then one could presumably, right, it certainly is arguable that after legislative fact-finding, the appropriate legislative body determined that this was a problem that needed to be addressed and addressed it, right? And so I just encourage you to consider many of the alternatives to the argumentations that the argumentation that you're making currently. Okay, I'm gonna just. There are many more comments that I'll take up with you individually. Let me just say that I do think that one of the strongest parts in the paper now currently is the dialogue you have surrounding the PTO's responses in courts to questions of court packing, as it were, right, of panel packing. I think that that's an incredibly powerful section. I would actually suggest that you maybe try to find a way to move it up in the paper and use it as a way to particularly motivate these underlying presumptions that you have. Because what I'm afraid of now is that the paper, it backloads that in a way that left me sort of my mouth watering until the very end when I finally said, now I see where this is coming from. Or at least, as I said in the beginning, close the circle on those premises you're using. So sorry if that was a little bit disorganized. Great paper. I encourage you to read it, and sorry for going over time. Thanks.
Thanks, Stuart. Chris, Melissa?
So this is an absolute Agency Adjudication Geek Fest conference. I'm so excited to be here as an administrative law generalist that spends a lot of time thinking about agency adjudication. When the PTAB was created and the cases started to trickle through the courts, I was just fascinated with this new administrative adjudicatory body and its role, in part because most agency adjudications I look at in immigration, veterans, and other contexts, you don't have as much money at stake, and you don't have the same type of design issues that you have here. And so when this conference opportunity came up, I called Melissa and said, let's do a project, let's do something, let's figure out where this PTAB fits into the modern agency adjudication landscape. And so that's what this project is about, is taking a step back, kind of looking at where we're at in agency adjudication more generally, and then figuring out where does PTAB fit in. And so to kind of give you a sense of, do I got slides yet? Oh, no, we're still waiting. That's all right. To kind of give you,
It's a feature, not a bug.
is it? I would call that a bug, but if you took administrative law in law school, you probably learned about, when you got to adjudication, you probably didn't spend that much time on it, but what you learned was that there's this formal process of formal adjudication. And Dick Pierce, in his venerable administrative law treatise, gives us like 10 kind of the keystones or cornerstones of formal adjudication and what they look like. I'm too close to the mic. Okay, thanks, Adam. And this is kind of your classic formal adjudication. You get a notice. You have an oral hearing before the agency as a whole or before an administrative law judge. Those administrative law judges have to be unbiased. You can challenge them for bias. There's limitations on ex parte communications. There's availability of legal counsel or other counsel. There's the burden of proof is on the proponent. The party is entitled to put on evidence and witnesses and to cross-examine the other witnesses. The decision is limited to the hearing. The decision has to provide reasons, and the party is entitled to a transcript of the whole record so they can run to court and challenge it. That's what you learn about in administrative law with formal agency adjudication. And that's what traditionally, at least in 1946 when the Administrative Procedure Act was enacted, what we envisioned when we thought about a trial-like formal adjudication. Now, it turns out that this is not, the mainstream anymore of adjudication, but we still see it in a number of places. And I want to kind of just flag. So you're thinking about kind of classic. There are about 2,000 administrative law judges, which is kind of usually what we think of when we think of formal adjudication of the APA. 1,800 of them are at the Social Security Administration. And so that's where you get a lot of formal adjudication today. One thing that's left out of Dick Pierce's treatise that as we've tried to sort out what adjudication looks like today and why the PTAB is different, is that it doesn't mention agency head control. So in the Administrative Procedure Act, it commands that when an administrative law judge that decision is reviewed de novo by the head of the agency. So they do their findings, they issue an opinion, and then you can go to the head of the agency. At the SEC, that would be the full commission. At the Social Security Administration, because they hear so many cases, the Secretary of Health and Human Services actually delegated that authority to an appeals council, but can pick up cases whenever that she wants in order to decide them as well. So that is a cornerstone that we have of formal adjudication under the APA. But like I was saying, most adjudication today doesn't fit this formal model. It's a little bit it's still a formal trial-like proceeding, but it doesn't necessarily have all of those attributes that Dick Pierce has mentioned that the APA requires for it to be technically formal under the Administrative Procedure Act. And just to kind of give you a sense, there's been a fair amount of work lately done by the Administrative Counsel of the United States, a federal agency that does research on federal agencies. In case you didn't think we had enough agencies, we've got one that does research on federal agencies as well. But they've done a lot of work on these trial-like adjudications that fall short of the Administrative Procedure Act. And they're really diverse. And to kind of give you a sense, the total number of adjudicators that aren't administrative law judges but still preside over trial-like proceedings in agencies is 10,000. So there are 2,000 ALJs, administrative law judges, and there are 10,000 administrative judges. And some of your kind of main areas you think about on the mass adjudication side are immigration and veterans. Those aren't formal APA-governed adjudications because they use administrative judges or immigration judges. And so you get a big variety of it. Fortunately for us, Melissa and I didn't have as much work in this paper to do because the Administrative Conference of the United States issued a report and has a huge database that has collected all of these types of adjudications. And they came forward with some best practices of what we need to have in an adjudication. And they did a nice profile in the PTAB, so I've just kind of represented this here. I'm not going to go through all of them here, but if we want to talk more about them in the Q&A, I'm happy to. But it turns out that among all the best practices, the PTAB actually does quite well. It's a pretty robust, from procedure perspective. It's incorporated almost all of these best practices that we have. Now, it's not formal APA adjudication because they're patent administrative judges and there are a number of other things that are different. At least that's my position. Melissa and I are still kind of debating that, but I think I'm right. Emily will give us a little bit more of why I'm right in a couple hours. But it is a pretty robust trial-like adjudication as it goes. Now, again, one thing I want to hammer home before I turn it over to Melissa to talk a little bit more about where the PTAB fits in, is that in these informal adjudications, with the exception of 6 of them that are very, very minor, that also happen to deal with private rights, or at least enforcement proceedings between individuals, and we can get into that in a minute, they all have agency head control too. So if you think about, like, for instance, immigration, you've got an immigration judge that makes the initial decision. The non-citizen can then petition that for review by the Board of Immigration Appeals. At that stage, the Attorney General, at any point, he can come in and take the case and decide it himself. And so you have agency head control, the final decision-making authority there as well. And that seems to be a feature throughout all of modern agency adjudication that I think, as Melissa will talk about, is absent here. So I'll stop there. In the Q&A, I mean, most of the work we've done so far, at least, it has been just looking at dozens and dozens of different agency adjudication frameworks, and that's what's in the paper, at least in the parts that are long and boring, or at least for me, awesome and geeky, before we kind of get to the idea of where the PTAB fits in. So.
Okay. So I just want to very briefly also thank the conference organizers. What a fantastic topic, right, in a very historically neglected area that's become incredibly important, this sort of intersection of admin, patent, and constitutional law. So let me just pick up from where Chris stopped. And I think there's several reasons why agency head review is so prevalent with respect to this APA-governed formal adjudication and these sort of type B, which we refer to these adjudications that PTAB fits in, which are very formal-like, but arguably don't meet all the APA requirements. And the lack of agency head review that we have in PTAB, right, may raise several concerns. So first, the lack of agency head review arguably hampers the director's ability to control the regulatory scheme that she oversees. And second, the lack of review could also frustrate the ability of the director to bring homogeneity to adjudicatory outcomes, which may be especially important for an agency like the Patent Office, because PTAB could be seen as sort of a mass adjudicator or makes many decisions, right? So there's concern that there's conflicts. So how does the director influence PTAB outcomes right now without sort of a direct agency head review? Well, the primary way is that the Patent Act grants the director influence over PTAB outcomes by enabling her to designate the members of the board, right? And this controversial practice typically occurs if you have a panel, a 3-member panel that comes out that the director does not agree, right, that doesn't think it implements agency policy. A rehearing and expanded panel is granted, because usually the party who loses always requests for that. And then the director, and now this authority has been delegated to the chief administrative patent judge, can select like-minded PTAB judges, right, to place on that expanded panel in hopes that the expanded panel will overturn the original 3-member decision, right? And the director has utilized this power before, and they had the same sort of power under the old board, the BPAI, and perhaps most famously in some patentable subject matter cases, including In re Allopat and Bilski, where the director had granted the request for a rehearing and stacked the panel with like-minded individuals that resulted in the initial board decision being overturned. And they've also utilized it to bring homogeneity to board decisions. So Target Corp versus Destination Maternity is an example that involved an expanded panel order with issues of joinder, where there are arguably conflicting board decisions on joinder practices. So in the paper, we explore whether the director has the statutory authority to do this, which we think, yes, she does, whether this raises some constitutional sort of due process concerns. And there's a Sixth Circuit case, Utica, that we can get into during the Q&A that I think raises some concerns, although we don't come out whether it's clearly a violation. And we also plan to explore whether there's any sort of APA arbitrary, capricious, reasoned decision-making violation. So, are there other ways right, that the director could utilize to bring homogeneity to board decisions or align them more with the agency's preferences that may not be as controversial, right? Perhaps the most direct route would be giving the director review over board decisions, right? Given the increased popularity of PTAB decisions, we think it would be best that the director's jurisdiction would be discretionary, not mandatory, but allowing the director to review only those decisions that she seems don't align with the agency's preferences, or to review ones that are inconsistent with other board decisions, right, would ease her administrative burden while still giving some sufficient control over adjudicatory outcomes. Alternatively, Congress could consider creating an intermediate appeal board, right, that then could be further subject to discretionary review by the director. Providing this intermediate appeal board and discretionary director evaluation could lessen the demands on the director and facilitate the identification of cases, right, where there's inconsistency with the agency's preferences. Now, both the downside of both of these proposals, of course, it would create congressional action. So are there other things that the agency could do to influence sort of the control over the adjudicatory outcomes? And one is, yes, I think there's a couple. One would be that the agency has broad rulemaking authority, right? They were given under AIA with the new PTAB adjudicatory decisions. And one way they could move forward would be to rely upon this more frequently, and this is in somewhat have been the critiques against the PTO to date, right, is that they're not promulgating enough rules, right, when they're announcing their policy. So I think they could embrace this more. I'm not sure that this would be enough to solely bring consistency. So the other thing we explore in the paper would be increased reliance on designating PTAB determinations as precedential, right? So this pathway, if they went down this route, would likely require the agency having to modify the process by which they designate PTAB adjudications as precedential, to give the director or the chief administrative patent judge greater control over this determination, right? And because precedential opinions are binding all future cases, whenever a PTAB decision is designated as precedential, it should bind future PTAB decisions, which would help bring more consistency to outcomes. So since these new adjudicatory procedures have come online, right, PTAB has issued about 1,500 written decisions. Last time I checked, only about 9 had been designated as precedential in the trial, the PTAB trials. And this seems like an alarmingly low number given the number of novel legal questions the board has had to deal with the AIA. And in part, I think the lack of the number of precedential opinions is because it's a rather cumbersome process that the agency currently utilizes to designate opinions as precedential. So you have to have an opinion be nominated, then you have to have, it goes out almost as a notice and comment period to the administrative patent judges. They vote, and you have to have the majority of voting APJs, which now they're close to 300 to vote. It should be precedential, and then the director also has to agree. So one way you could move forward would be to consider giving the director more unilateral control over which decisions are deemed as precedential, which would give her more flexibility and perhaps allow them to use this as a pathway to bring greater consistency. So that's it.
Great. Thank you. Well, it was a pleasure to get to read this paper. I'm looking forward to its publication. I think it's going to be a very important and useful paper. I do have to note at the outset that if Chris isn't tired of me already, he will be. We were on an event yesterday for the Federal Society, today here, tomorrow a different conference, and evidently next week a debate, so I'm like a bad penny he can't get rid of. Although I have the easier task of just commenting on his good work and just sort of throwing brickbats at him. Like I said, it's a good paper and an important paper, and I want to make just a few very general points. First, focusing on Chris and Melissa's key point, right? The PTAB is not formal adjudication. Why? Well, for two main reasons. The first is that the PTAB process just lacks that assortment of formalized procedural protections that we expect of formal adjudication, right? These things that that formal adjudication would otherwise require to ensure the independence of the initial decision maker, right? Now they say this is adjudication outside of the APA. It might be a little bit more precise to say what outside of the APA's formal adjudication protections, because it is still subject to the APA in some ways, including maybe Section 555. But they're right, this is outside of what we generally think of as APA adjudication. Although, as they already mentioned, so much of what agencies do in the course of adjudication is outside of what we think of as formal adjudication. Their second reason for why the PTAB process is not formal adjudication is it's not subject to the control or final decision of the head of the agency, so to speak. The director of the Patent Office can do a lot to influence the process, as we already discussed, but he isn't singularly in control of the final decision. And at risk of making an obvious point, but I think it's an important point, it's just interesting always, I think, to notice the tension between those 2 points. Right? The first point is that the PTAB doesn't look enough like a court because it doesn't have these formalized protections that guarantee the independence of the decision maker in ruling on law and fact. It doesn't look enough like a court. The second point is that it doesn't look enough like a sort of executive branch agency, right? It's not susceptible to the control of the head of the agency, and thus not subject to the influence, the direct influence, or the full influence of politics in its best and worst sense. Right? At one point in the paper, they say the PTAB is kind of a platypus. What a wonderful word for this, and an accurate one. And it has features of both a court and an agency, and we criticize it for not having enough features of a court or an agency. So it's just interesting to see that tension. It reminded me, in a way, to borrow or adapt an old joke the school's namesake Justice Scalia once used. One friend asks another, "How's your husband?" And the friend replies, "Well, I don't know, depends compared to what." Right? How's PTAB? Well, I don't know, it depends compared to what? What are we trying to compare it to? Because our evaluation of PTAB ultimately depends on our premises, right? What are our views of what the PTAB is supposed to do? What's the PTAB supposed to be? Right? If we want the PTAB to promote expertise, expedience, and efficiency, right, then maybe reducing some of the formalities of formal adjudication and making it a much swifter, executive decision maker, right, is a great thing, right? And better to put the director of the office in charge of it to make sure that these individual cases ultimately align with the department's broader policies and programs. But if we think that the more fundamental question is, what's the nature of the rights that are being adjudicated here? Right? And I'll get back to the word adjudication in a minute, but what's the nature of the rights that are at issue? Right? This is the classic debate through all of administrative law over agency adjudication. Right? Are we talking here about public benefits that have been created by Congress or an agency being bestowed upon the public at the agency's discretion? Right? Is this what we call a public right or a public benefit? Well, then we're comfortable or more comfortable with the agency not being susceptible to or not being subject to the same sorts of court-like protections. Right? But if we think what's happening here is the adjudication of private rights that pre-exist this regulatory structure, right? Rights that are more fundamental in law than this regulatory apparatus that rides on top of it, well, then we suddenly want it to look more like a court, right? We become more uncomfortable with the idea that this body can maybe arbitrarily affect or cancel out or nullify people's private rights, right? If it's a public right, we're more comfortable with political control. If what we think intellectual property is a private right, then we might want it to look more like a court. And so I think my main suggestion for the paper going forward, there's already a lot in there, it does a lot of good, but the main suggestion would be to really show what the upshot of all this is. If the agency were to look more like a court, what would the benefit of that be? If it were to look more like a swift, efficient executive agency, what would the benefit of that be? And that's to be judged both in terms of the nature of the right, but also the stakes, right? The economic stakes and the role of intellectual property in the modern American economy. So far I've been throwing around this term adjudication, we all have, but I do always like to sort of step back whenever we talk about agency adjudication, which inherently sort of presupposes we're talking about something court-like, right, or judge-like, adjudication, right? And we ought to stop and think about what we mean by the word adjudication. Because if adjudication isn't supposed to be judge-like or court-like, well then we should be careful about building in too many assumptions about what courts do into our critiques of adjudication. You know, it reminds me of something else from Justice Scalia. Everything reminds me of Justice Scalia. When all you have is a hammer, everything's a nail. When Justice Scalia's famous dissent in the line-item veto case, right, he blasted the majority for basically falling for a terminological head fake, right? By calling the line-item veto a line-item veto, Congress sort of built into the court's review this expectation, unfortunately for Congress, that what the president was doing was exercising a veto. Right? By calling it a line-item veto, the case challenging it fell into this box of well, how does a veto operate? How should a president use a veto? Can he veto just part of a bill? And the answers become pretty obvious. Well, Scalia's criticism in his dissent was, it's not a veto. It's not really a veto. It's the president limiting spending, right, impoundment or whatever. This is a power presidents have always had. It's not really a veto. And so judicial review of the constitutionality of a line-item veto shouldn't turn on the name line-item veto. We need to look at the substance. And I think that we should have the same caution in evaluating this form of agency adjudication, or any adjudication, right? Agency adjudication covers many things. As I just mentioned, it covers everything from adjudication of public benefits, right, to private rights, as we saw in the case, you know, the Supreme Court's CFTC versus Shore case, where even state law claims are getting bound up in this agency process. If adjudication can cover many, many things, maybe it's time to become much more precise in the law about what we think is or isn't an adjudication. Maybe the real problem is in the APA creating this catch-all phrase to cover many different categories. Right? Maybe a more accurate title for Melissa and Chris's paper wouldn't be The Lost World of Agency Adjudications. It's The Lost Worlds of Agency, instead of The Lost World of Agency Adjudication, The Lost Worlds of Agency Adjudications, right? And become more precise in that in the modern time, we're now sweeping in a lot of different things that maybe should be parsed a little bit more carefully, right? So in the end, I think the big questions that arise in this paper and throughout this conference are, what is intellectual property, right? And what is adjudication? I really encourage you all to read one of the papers that's outside on the table. It's a paper by Richard Epstein, where he sort of walks back through the nature of intellectual property as a private right and not just a public benefit. And also, of course, the amicus brief filed by Adam Mossoff and other intellectual law professors, sort of pressing this point, really pushing back very aggressively at the Solicitor General's position that intellectual property is just sort of a run-of-the-mill public benefit. I think was the way it's characterized in Richard's paper. And so I think the bottom line is that Congress and the courts need to grapple much more directly with these premises, right? To design or reform the PTAB process without starting with what is intellectual property and what is adjudication, right? It really puts the cart before the horse. It looks through the wrong end of the telescope, whatever metaphor you want to use. So in that respect, the oil states case is a real opportunity to return things to a sort of a proper starting point, to have a much broader conversation about how to reform PTAB. Because until we really understand what it is we think PTAB should what PTAB should be doing in terms of adjudication and the nature of intellectual property, everything that follows from the debate really is going to be ill anchored in first principles. Thank you.
Great, thank you. So I'm going to ask the panelists a few questions here before we open it up to the audience for Q&A. But first I wanted to say I really enjoyed reading the papers that you guys wrote, and I learned a lot, particularly from your paper about administrative law, which I'm an IP guy. I don't really know anything about admin law, so I really appreciated the beginning of your paper where you kind of explained everything in the different types of adjudications, and very helpful information, and I can't wait till you guys publish so everybody else can read it too. But towards the end of your paper, things started to get juicy, right? And then you kind of cut off, and I can't wait to see where you're going with some of these things. But in particular, I want to talk about panel stacking, because to me, this is like the craziest thing in the world, that they're just stacking panels until they get the result that they want. And you suggested in your paper, Chris and Melissa, that that it might violate due process, panel stacking. But then Saurabh in his paper mentioned in passing that maybe it doesn't violate due process. So I'm wondering, how do we reconcile the idea that just panel stacking itself might violate due process with your other argument that we want to give the agency head like final say and they can just say, hey, this patent's invalid? So it seems to me, well, what's the point of worrying about fairness and stacking the panels if we're just going to let the agency head have the final say anyway?
Yeah.
So
I can start with, So I think it's a really interesting, because when you think about it, that in most adjudications, you just have an agency head who can reverse largely for factual or legal determinations as long as they tell the reasons why, right? You can think of panel stacking as being functionally sort of equivalent to that, right? The agency head sort of stacks a panel to overcome an initial 3-panel decision, right? I think where, it's difficult and why we're trying to sort of drill down, and that's a part of the paper that we're still developing, has to do with this idea of is it functionally sort of equivalent? From a broad standpoint, it is. But there's a Sixth Circuit case that we talk about in Utica, right, that had to do with the U.S. Department of Agriculture, where they had brought a complaint against this Utica before an ALJ, right? And the ALJ made a decision, right, that the secretary agreed with, right, of the USDA. It got up to the Sixth Circuit, went back, and then they changed, right, because the Sixth Circuit told them they needed to reverse. And at that point, the secretary was very upset, right, pulled the judicial officer, who's like the Intermediate Appeal Board person, off, right, and put a new person in, and they reversed, right, their decision. And the Sixth Circuit said that constituted a due process violation, right? And so if you make analogies along those lines, is there something about the sort of transparency of the decision-making and who sort of initially is put that we think is different than just allowing an agency head to reverse? And in some ways, I think the due process concern with the transparency would be even more concerning if the director was stacking, or a director was choosing the initial 3 panelists, right? Which my understanding is not occurring, right? But we have no way of determining that. The only real way we see that the director being involved is through an expanded panel. You want to add?
Do you mind if I jump? So I have a hard time buying the due process argument, just because agency head control is kind of fundamental for agency adjudication. Although I will say, if Oil States comes out the way I don't think it'll come out, our paper will not be public. I mean, we're done, right?
Yeah.
But if it comes out the way I think it will come out, then our paper sets up Gary Lawson's paper for this afternoon perfectly, on why patent administrative judges are unconstitutional for other reasons. But when Adam was making his remarks, I think one way to think of this, when Adam's saying like these judges, we want them, administrative law judges, to be independent from the agency, and yet we have final agency control. I think that's the problem here. It's not a constitutional problem, but the idea with agency adjudication is that the first line adjudicator, either the administrative law judge, the patent administrative judge, the immigration judge, should have decisional independence. You shouldn't be able to interfere with her decision. She makes her decision, and sure, the agency head can then come out the other way and reviews de novo, and so there's no deference given to that initial adjudicator. But when the court reviews this, it sees the initial determination and the fact findings made by the adjudicator, and it sees how the agency came out a different way for policy reasons or whatever. And that's the type of process, not due process in the Constitution, but process under the Administrative Procedure Act of reasoned decision making. That I think that's the argument we're trying to make, is that it's more of an arbitrary and capricious. If you're stacking the panel, or if you're choosing who those adjudicators are, it's interfering with the frontline adjudicator's decisional independence.
But note, though, that we've talked about this, is that then that would suggest is the 3-board panel and then the expanded panel may be okay, right? Because you do have the reason, you have the opinion written for both one, and it's sort of transparent. You can almost think of the expanded panel as the agency head review.
Yeah, except but the agency head is expanding the panel to specifically choose people who are not.
Yeah, but no, but I'm saying
if
it's about transparency and having a written decision with the information, that's what I'm pushing back.
Yeah.
So we're still working through it, as you can see.
If you have a great argument for why panel stacking is unconstitutional or contrary to the APA, I would love to hear it, because it seems just so icky to me, but I can't really articulate
I think you two should fashion your paper like one of those old choose your own adventure books where you get to probably disagree and then.
It's kind of what it reads right now, Adam. But
Yeah, that's, you've read it, yes.
So can I just chime in on that issue? So this Sixth Circuit decision, I'm assuming it was a formal adjudication? Mm-hmm. Yeah. Did they deal at all with this question of how that decision related to the director's power, to the secretary's power?
Yeah, so what happened there was an ALJ who made the decision, and then the director had delegated her review authority to something called a judicial officer, which is like this intermediate board, right? And so the director, the secretary there was arguing like, I delegated it so I can just take it back and change that person that's in the intermediate board. And the Sixth Circuit said, no, once you've sort of delegated that to the individual and they made a determination, you can't then take it back and replace them with somebody else who you want to come out the other way.
So let me offer some input into this. When this came up, this question of whether it violates due process, whether it's appropriate for the screening function to be vested in the same entity, not just the PTAB, qua PTAB, but the same three-judge panel that's going to go on to adjudicate. That was something the Federal Circuit decided in a split decision called Ethicon v. Covidian, and it reflects many similarities, but it's not identical to the prior due process challenge that we saw with the Board of Patent Appeals and Interferences, which is a predecessor of the PTAB, in the Allopat case. Okay, so in Allopat, and between Allopat and Covidian, there's been, I think, some important changes, structural changes in the PTAB. First of all, in Allopat, the due process challenge wasn't resolved. The court said, as a bottom line matter, this doesn't pose a problem, but the due process sort of challenge as a challenge was deemed untimely and just sort of disregarded as moot. So when the court looked back on it now, the Federal Circuit looks back on it, they didn't, I think, take adequate account of the fact that in the Board of Patent Appeals and Interferences, when you engaged in panel stacking, as the commissioner engaged in that case, the people who were the initial decision makers were examiners in chief, right? The re-examiners who were chosen to sit on this panel initially were employees who worked in the competitive service. The PTAB judges, administrative patent judges, are not these lesser employees, mere functionaries, to sort of use the language of the governing case law. They are required to be named by the secretary. They cannot be hired by the director. Okay, and this was an experiment that Congress engaged in at the same time that the Board of Patent Appeals and Interferences was reconstituted to give the director more control over the administrative and policy direction of the office. The idea was, we'll make this person an undersecretary of commerce. Rather than a commissioner, will be a director. And the person will hire all these administrative patent judges and thereby exercise the control and create the uniformity that they should be able to do. Now, that was very compellingly shown to be unconstitutional in a law review article by Professor Duffy, who's in the audience here. And Congress went and said, okay, that's a mistake. It was unconstitutional. We shall now go back to the way things were, which is the secretary shall appoint these inferior officers who are subject to the Appointments Clause protections, right? If that's the case, if they have this greater importance, their functions are more substantial, their responsibilities are more significant, I think that counsels in favor of greater decisional independence in the way that the appellant in Ethicon v. Covidian argued. And the court didn't really take any constitutional account of that. So I think it's reconcilable, as I say in my paper draft. I think it's reconcilable with due process, but I think the problems that currently exist haven't all been solved. Because if it lends itself to these kinds of rehearings, one thing that was said earlier is that pretty much every case, the losing party seeks rehearing, right? Yeah. There's one situation that I point to in my paper where that didn't happen. And the current way of designating opinions precedential requires that the process for that designation be followed vis-a-vis voting by the PTAB judges, nomination by the and so on, and then approval by the director. If you want to engage in panel stacking as a way of creating coherence in the case law, then you have to have rehearing. And if that's what the agency is subsequently using to say, look, we've stacked panels as frequently and as effectively as we can to demonstrate that we're speaking with the force of law for purposes of asking for Chevron deference,
Wow.
surely the precedential status and Chevron deference due to the agency shouldn't be held hostage to whether a litigant thought it was strategically useful to ask for rehearing or not. So that's my sort of meat on the bones of why it feels icky and why it might be worth revisiting.
Great, thanks. So I have one more question, and then I'll open it up to the floor. So I understand that the idea with the panel stacking is that we're trying to get uniformity and homogeneity, and we're promoting the director's policy judgment. I get that, but I'm wondering why are we doing that? So, I mean, in the context of oil states, we have an IPR, an inter partes review. And the question there is, we have an issued patent, and there's some new prior art, and so are we going to invalidate the patent on novelty or non-obviousness grounds, right? So to me, that it's going to follow the law that was established by Congress, interpreted by Article III courts, the Federal Circuit, the Supreme Court. To me, like, those are the policy judgments that should matter. Why are we trying to get uniformity based on what the director thinks? And it seems, if anything, when we give examiners new guidance in the manual, we look at what the courts say and we say, do what the courts say. You need to follow what the courts say. But here, it almost sounds to me like there's some kind of, like, I don't know, ultra vires or something where we're going to say, hey, what does the director think? And so, and as a fix to the panel stacking, you mentioned that we can make more of the decisions precedential. I think you mentioned, Melissa, that there's like 9, maybe 10
Yeah.
decisions that have been marked
For
that way.
trials.
But my understanding is that those decisions, they're non-substantive as far as patent law goes, right? So they don't say anything about like the substantive law of novelty or obviousness. So I'm trying to understand how that would actually get the uniformity that you're saying we need.
Yeah, so let me be clear, like, so clearly the Patent Act, we start with that, right? And we have all this case law from the Federal Circuit that's interpreting that as well. But there is still, even with all of that, there is still a lot of gaps, right? And there's still sort of new technology that's constantly coming online, right? Where the PTO inevitably has to fill in some holes, right? And now they don't have, substantive rulemaking authority, and I'm not saying that they do, but they need to give some guidance. They have 9,000 patent examiners that are making determinations. Otherwise, we would just have them all sort of guessing on what to do in these sort of gaps or areas. And so that's where I'm envisioning the director having a say. And it doesn't have to always be substantive law. The example I gave with the Target case had to do with joinder, right? And so there is both, non-homogeneity and procedural issues and substantive. But in Realipad, for example, was about patentable subject matter, right? I think anyone who's read the Supreme Court's patentable subject matter jurisprudence realizes there's need for additional guidance, right, for what examiners are doing. And that's the type of role that I'm thinking of, where the director can sort of step in and say what the agency's best policy is to help bring some uniformity. Now, there's a bigger than debate, right, as far as what deference standard I think the Federal Circuit should owe PTAB's determinations, but I'm not at all suggesting, right, the director is getting to overturn or go against, right, what we think is already settled law.
And, let me just add to that. I think that that probably many people in this room have actually seen the empirical evidence that supports that. Anytime that the court speaks, the patent office is put in the position of having to issue guidance to the examiners. And indeed, there's a lot of gap filling there. Sometimes with some of the recent Supreme Court jurisprudence, there are a heck of a lot more gaps than many people would like. Without giving personal knowledge, we can expect that the director is very much involved in that process of gap filling.
Anybody else?
One just additional point regarding rulemaking authority and substantive rulemaking authority. It's not just about what the propositions of law that are contained in the Patent Act contain. Melissa's point about technology is very well taken. A lot of factual development and how those factual developments in the record of a particular examination or in the record of of reexamination, review, and so on. If you're not providing adequate factual support in the way that the law requires, then you're going to get dinged on Chenery, even though the 102 answer or the 103 answer might have been right. And the Federal Circuit, to its credit, has been holding the agency accountable much more than it used to by sending these decisions down, saying, look, you haven't given us enough in the way of a Chenery analysis. So I think that's an area in which, quite apart from rulemaking authority, the director can exercise substantial control in a very helpful way.
Great, so we're going to open it up to you guys. I have a hand right here. Oh, and please wait till you have the mic before you speak. And we have the second gentleman back here.
Precedential opinions. I think that the...
David, could you identify yourself?
Oh, I'm David Boundy. I'm a lawyer in Boston. I'm not an academic. And I, in fact, have a paper on almost this topic coming out next week in ABA Landslide. Rulemaking by adjudication. I think the Patent Office has been getting itself in deeper trouble over the last 6 months, and I think any recommendation has to be very circumscribed, especially after Aqua Products 2 or 3 weeks ago. First is, basic principles of rulemaking by adjudication. It's limited to only that interpretative space, right? That you interpreting ambiguities. The place that the PTAB got itself in trouble was by trying to create a new rule out of whole cloth by adjudication. The PTAB is not an Article III court, and they just don't, NLRB versus, come on, the NLRB adjudication by rulemaking case.
Bell Aerospace?
Bell Aerospace, yeah, thank you. And Palm Wonderful from the Ninth Circuit. It's fine to do interpretative rulemaking when it's outside the agency, but then interpretative rulemaking comes with that funny kind of binding. It's kind of post-it note binding authority, right? It only applies unilaterally against the agency. If it's an interpretative rule, I can go back and say, well, yes, you decided this as a precedential decision, but you can't stick me with it. If I've got a better argument under the substantive law, you have to entertain that argument. You can still rule against me, but you can't use an interpretative rule as the last word on the issue. Let's see, even if it's a rule within the agency's jurisdiction, is a precedential decision enough process to get you into the Chevron deference column? Sometimes it is, sometimes it isn't, but just precedential decision with no public participation, that's in that gray area that's left under Mead. And finally, the Paperwork Reduction Act. A lot of what the PTAB would want to do by precedential rulemaking runs into problems under the Paperwork Reduction Act on procedural issues. So it's not a panacea. It's got a lot of boundaries on it.
So I just want to say one quick thing. I do think, so my view, and I think Chris's as well, is that the new PTAB adjudications are formal enough alike to get and possibly into the Chevron land, right? I do think one of the indicators that would help would typically be indicating something as precedential. However, it's less clear to me if we move in the direction that we're talking about, where the director has complete control, which way that cuts, right? Because now there is more arguably process by having the majority of the 300 APJs voting, right? And some of that could be thought of as, and there's sort of a notice and comment period, at least within the APJs, on what becomes precedential in an adjudication, where it's sort of, I haven't sort of worked out whether I think our proposal would be stronger or weaker.
Yeah, I would just add, and I was trying to kind of follow through that, agencies in adjudication get Chevron all the time. I mean, this is not anything new. In fact, Kent Barton and I just finished 3 years of reading almost 2,000 decisions on Chevron, and agencies win as much They have Chevron applied just as much in adjudications as they do in rulemaking. They actually win a little bit more. Now, granted, it could be that they're less aggressive in their interpretive efforts in adjudication. We couldn't account for that in our coding. But I don't think it's that unusual for Chevron now. And the arguments that, oh, it's not notice and comment, there's not public input.
Yeah.
I think those are all really great arguments. Courts haven't cared about them, though. It's not really a part of Chevron. Yeah.
area you're talking about of substantive law, you don't get Chevron deference. The PTAB could not possibly get Chevron deference on an issue of substantive patent law, Chevron step 0. They don't have the substantive law authority.
Yeah.
I'm not sure. I mean, that's definitely not what that was not the Solicitor General's position in Quozo, at least. So we'll see where that goes. But yeah.
Well,
Quozo's a special case because there are, kind of that Aleutian chain of islands of substantive rulemaking authority in the IPR statute. I don't have any problem with the PTAB having substantive rulemaking authority on those isolated issues in IPRs and PGRs. And I think the solicitor's fine there. But on obviousness or McAward, the indefiniteness case from a couple months ago, that's way outside any conceivable scope of substantive rulemaking jurisdiction.
At least that wasn't the Solicitor General's position in the briefing for Quozo. I mean, it took a pretty broad view of core substantive patent law would even be within what the American Invents Act. I don't know. I think we're going to find out sooner than later because the PTAB is going to do it.
Well, they already have.
But they're going to eventually ask for Chevron deference.
Yeah.
All right, so let's take a question from the gentleman in the back.
Josh Sarnoff at DePaul. So let's just acknowledge that law and most rule interpretation, maybe some application of fact, is political in a sense, right? That's why we want the head of the agency to make those kinds of decisions, and that's why it's awkward when we have adjudicators who are not agency decision makers in the same way making those decisions. So how do we solve this problem? There's actually an easy way to do it, except that power abhors being given away. What we do is we get the patent office to write a rule that requires any question of interpretation of the law or of the rules be certified to the director before a decision gets issued. The administrator, because of how long it's going to take to issue rules, will never issue the rules. He issues a guidance. Policy guidance then isn't subject to Chevron deference, but the agency now has guidance on the issue before they issue a decision. The only issue that's left is the one I disagree with my good friend Dave Boundy about, which is whether the agency employees on the PTAB would then actually be obligated to follow the guidance. My view is they're not. Nevertheless, the guidance is out there.
Right.
But if they are, it solves the problem entirely. Doesn't mean that you don't get judicial review to overturn the guidance. Then you get Devlin getting the courts to say whether it's right or wrong. Simple solution.
Maybe think more about
Any
that.
comments?
It would definitely be a novel from looking at other contexts of agency adjudication. That's a very, very novel approach.
Yeah, other agency adjudicate, like the FCC certifies policy questions,
Yeah.
right? So there is a model for that where you could imagine just saying PTAB, anytime they have a new question of law that they're looking at, needs to be certified to the director, and I think that's a model. I put that more in the category of having some more direct review, right?
And before the agency issues a rule requiring the PTAB to do it, which the director has the authority to issue because he's got the right to write these rules, just have the director of the PTAB, the chief judge of the PTAB, impose it and say everybody's going to send a question to the director for the policy guidance to issue.
Yeah, but I do think there's a question, as you point out, that if they go by and do it through a guidance document, it's unclear to me that that's binding on the APJs.
Yes, but if it isn't, that's a function of deep administrative law issues. It has nothing to do with the problem here. And it still is better to have the agency statement and guidance and then say they didn't follow it. You solved the problem.
I guess we're done.
We have a question here in the middle, and then Dimitri in the back. What?
So, Adam, one thing that you said earlier about the PTAB kind of not being like a court, more just agency adjudication. I'm curious what those in the panel think about the applicability of sovereign immunity to IPRs, which has been sort of a hot topic both for tribal nations and for state actors.
That's for the whole panel?
Do you want to tackle it?
No, I mean, that's a good question.
No, I'm not going to comment on it. No, I'm not going to comment on it.
I haven't thought
This is
about
being
it.
taped. I'm not commenting on that.
I mean, this is one area where I think my initial presumption would be PTAB adjudication is within the APA, right? It does seem to fall within the broad waiver of sovereign immunity in the APA itself. But that's a good question that I haven't thought of, so I'm just going to stop talking now.
Yeah.
All right, let's get to Dimitri.
Oh, here we go.
Dimitri Karsta, GW. Actually, I have a related question. What do Melissa and Chris make of the request for amicus briefing in St. Regis, Mohawk, right? Is that notice and comment rulemaking? Why this case? It says it's an issue of first impression, but there have been many PTAB cases involving issue of first impression. Is that typical for agencies to request amicus briefing? Just curious.
No, it's not. I'm not familiar. I have not been following this case, but that's not in other contexts. That's not normal. Of course, nowadays you can just throw it up on a blog, and Chairman Pai at the FCC is going to see it once you tweet it out. So I'm not sure what the.
John in the back. Somebody have a mic?
Thanks. I have one comment on Sarab's paper that's then relevant. Use this one? Okay.
It's louder.
It's louder. Okay. Sounds like the booming voice now. So one comment on Sarab's paper, and it leads directly into a question for Melissa's paper and Adam White and Christopher Walker's paper the commenter on the paper for Adam White. So the first point is that you said that with the respect to the patent granting function that there's no judicial review. And that's not really right. It's asymmetric judicial review coming from examiners, because if the patent office denies a patent, then you do go to the board and you do get judicial review. So it's a problem of asymmetric, or it's a feature which is rare in administrative law of asymmetric judicial review, which leads to my question, which is, if you thought of IPRs in the following way, if Congress, instead of doing IPRs, had just said the following: patent issuances are subject to judicial review under the APA. In other words, they overruled Federal Circuit precedent that says that the Patent Act impliedly precludes judicial review under the APA, which I think, in full disclosure, I litigated that case and lost. Actually, the case we won everything in the case, which is why there was no cert petition. But that issue we lost, but let's say Congress overruled that, and then and then that's step one. And step two is that the Congress puts in a special provision that says, which just I think formalizes something that could happen, if the director reads the briefs of the petitioner and thinks it's more likely than not that one or more claims won't survive judicial review, the director can seek remand from the court, which under rather standard administrative law, the court, Supreme Court law and DC Circuit law says that the court should almost always grant. So let's say that we did that, and then you get a remand, and then you send it to the board for better reasoning. And you say, look, this is not an adjudication, it's not inter partes, but we're going to allow the challenger to present the evidence and the arguments to the board. Of course, the patentee can be, like an intervener, or can also put in their arguments and respond to these arguments. But ultimately, it would be sort of a way of thinking about inter partes review that solves the asymmetric judicial review problem. That essentially right now, if you get a patent, it goes right out, never goes to the board. And instead of that, you say basically, when a patent goes out, it's going to be subject to judicial review. Now, I think that would just generally be a good idea and would be consistent with administrative law. But if the director actually thinks that, one or more claims aren't going to survive, it makes no sense to go to judicial review. Why not just seek a remand? And that, it seems to me, is the right way from a fundamental theory of separation of powers to think about this, that it's not really anything more than an extension of the original granting decision, which, because it's ex parte and also because of crazy federal circuit law, is asymmetrically judicially reviewed. This is just getting back to granting judicial review of these and then basically saying, if it's not going to survive judicial review, it doesn't make sense to actually have judicial review. The board gets to put in better reasoned decision making so that it can at least potentially survive judicial review. Now, sometimes the board will come and look at the arguments and say, this does not survive, it's never going to survive reasoned decision making because the patent should not have been granted. But it seems to me that that's a way of thinking about the inter partes system that fits it within standard administrative law. And really, to the extent it's non-standard, it's only because asymmetric judicial review is incredibly non-standard in administrative law. So I wondered if you had a comment on that. And that obviously, Saurabh, I think you have to make an adjustment to the paper on that little point. But then if you had a comment on that.
I do, because I'm confused that this is standard administrative law in adjudication. I mean, almost all the benefits cases, if the government loses, there's no judicial review. I mean, if a benefit is granted, if an immigrant gets to stay in the United States, if Social Security, veteran, there's no judicial review of that.
Well, not if somebody's adversely affected or aggrieved, it is standard review. And if somebody grants a patent and I'm a competitor in that industry, it suddenly says I can't do X, whatever's in the claim. And normal judicial review would say, like, if the FCC grants a license.
Well, normal judicial review, I mean, give me one example of administrative law, agency adjudication, where it's an ex parte adjudication originally, and a benefit is granted, where someone who is not a part of that could seek judicial review of that other. I'm blanking. Maybe I'm missing some.
So I guess to the extent that you view, I think I would object to the analogy of it being a benefit.
Well, any example, any right, anything, yeah, anything that's granted by an agency. Yeah.
It constrains the freedom of another party, and therefore you would, under just sort of standard application of the test of judicial review.
But like, what's one example of an agency adjudication period where?
So the ex parte thing is unusual, okay? That's another unusual thing, that the person whose rights are going to be also adjudicated in this don't get any representation. But that, I think, goes back to history about keeping patent applications silent. But I think that if maybe you're right to say, well, maybe at least it's standard judicial practice that if it's ex parte, maybe you don't get judicial review, because I think it is a little unusual to have an ex parte proceeding where somebody else's rights are being adjudicated and constrained. Their freedom is being constrained. Their liberty is being constrained by executive action. So there is some unusual structure there, but you would think that, you usually would think that people who are adversely affected and aggrieved by administrative action do get judicial review. Maybe you're most benefit cases don't constrain anybody else. Nobody else is adversely affected or aggrieved, right?
All right, so Adam hasn't thought.
Well, I just want one example of standard administrative adjudication where you're right. I mean, this might be like the fairness of judicial review, but it has nothing to do with agency adjudication. And it might also mean that oil states needs to come out the way that some people want it to come out, that it's just unconstitutional to have agency adjudication of patent rights. But I just have a hard time seeing why this is any different than kind of run-of-the-mill adjudication.
I was just going to add, John, I like this idea a lot, although I'm struck by, if this were to come to pass, these precedents in which the courts regularly allow the agency to sort of reel back in a decision for another go at it, I wonder how stable those precedents would be, right? If the director is seen as you teed it up, taking an objective look at the prospects for success in court, deciding that it's probably not a winner in court and bringing it back, well, then the courts would probably be amenable to that. But if it looked like the director was actually gaming it, right, to bring a case back and get, to change the decision for other reasons, right? If it didn't look like he was genuinely concerned just about the prospect for success in court, that maybe the courts in turn would recalibrate their own precedents on when they allow the agencies to have
Well, those
take back the
precedents
issue.
do allow the agency to request a remand if they think even the record is inadequate, which
Yeah.
I think is what often happens. I mean, the problem that the inter partes system is trying to address is that it is an ex parte process, and therefore, usually the agency doesn't have good access to the prior art, doesn't have the arguments on the other side. And if you apply sort of standard principles of reasoned decision-making, they just usually haven't looked at the right stuff. Now, the agency could try to defend and say, well, none of it was before us, so it's reasoned decision-making given what was before us. But oftentimes, at least there's actually, at least DC Circuit precedent, I think actually this may, part of these remand precedents come from Supreme Court precedent, part come from DC Circuit precedent, but they're not that controversial as these things go. And at least some of them allow remands just to sort of shore up the record.
That's a good idea.
Well, unfortunately, and with apologies to Josh and the others who had their hands up, we're out of time on this panel. And I want to thank everybody for the excellent questions. And of course, I want to thank all of the panelists for the excellent discussion. And thank you very much.